everyone. This is week 4 of the Compliance Boot Camp, and we are talking about books and records. Let's go ahead and get started. So generally, as a registered investment advisor, you must make and keep true and accurate and current books and records relating to your business. There's also, under the Books and Records Rule 204-2, the books and records that you make and keep are quite specific, and I go into what they are here on this slide. So advisory, business, financial, and accounting records, records that pertain to providing investment advice and transactions and client accounts, records that document your authority to conduct business and client accounts, advertising and performance records, records related to the code of ethics, records regarding the maintenance and delivery of your written disclosure document, and disclosure documents provided. Hey everyone, it's week 4 and we're talking about books and records. So let's go ahead and dive in. So generally, as a registered investment advisor, you must make and keep true, accurate, and current certain books and records relating to your investment advisory business. These all fall under the Books and Records Rule 204-2. And under the rule, the records you have to keep are actually quite specific, and I describe them in part here on the slide. So advisory, business, financial, and accounting records, records that pertain to providing investment advice, and transactions in client accounts with respect to that advice, records that document your authority to conduct business and client accounts, advertising and performance records, records related to the Code of Ethics rule, records regarding the maintenance and delivery of your Form 80B, especially where it's provided by solicitors who seek clients on your behalf, and then policies and procedures adopted and implemented under the compliance rule. Some advisors are required to maintain additional records. For example, advisors that have custody and possession of client funds and or securities must make and keep additional records that are described in more depth in the Books and Records Rule. And advisors who provide investment supervisory or management services to any client must also make and keep additional records. So how long do you keep records? Generally, most books and records must be kept for 5 years from the last day of the fiscal year in which the last entry was made on the document or that the document was disseminated. You may be required to keep certain records for longer periods of time, such as records that support performance calculations used in advertisements. And you're also required to keep your records in an easily accessible location. In addition, for the first 2 of these years, you must keep those records in your office. If you maintain some of your original books and records somewhere other than the principal office and place of business, you must note this practice and identify the alternative location on your Form 80B. Many advisors store duplicate copies of advisory records in a location separate from the principal office, and they do that to ensure continuity of their business in the case of any disaster. So the most recent that I can think of are these hurricanes that have come through the southeast the last month or so. So if you had an office in Florida or South Carolina and also an office in Colorado, some advisors choose to keep duplicate copies in the Florida office and the Colorado office in case something happens with the Florida office, for example. And then some books and records are subject to different preservation requirements. So, for example, the partnership articles and any amendments, articles of incorporation, minute books, etc. They should be at the main office of the investment advisor and then preserved until at least 3 years after termination of the enterprise. So electronic storage. You may store your books and records by using either micrographic media or electronic media. And this can include microfilm, which who the hell uses that anymore, or digital formats like electronic text, digital images, any sort of software, email. If you use email or instant messaging to make and keep records that you're required to keep under the Advisors Act, you should keep the email, including all attachments that are required records, as examiners may request a copy of the complete record. This is why a lot of people choose to use companies like Smarsh that do a really good job of that email retention and keeping those records in one place. In dealing with electronic records, you must also take precautions to ensure that they are secure from unauthorized access and theft or unintended destruction. In general, you should be able to promptly, which is within 24 hours, produce required electronic records that may be requested by the SEC staff, including email. So you want to make sure that your emails are arranged and indexed in a way that permits easy location, access, and retrieval of any particular electronic record. Now, this is difficult with emails because especially if you have several members on your staff, you're dealing with a lot of people who are emailing back and forth every single day. So using a third-party provider that can store your emails and provide a way to index. Especially what's useful is if you are using an attorney, you know, you want to be able to have certain email addresses scrubbed from production, so you don't want to produce records from your lawyer to regulators. So, you know, looking at different providers out there, a lot of advisors I know when they're first starting out, they'll use a provider like Outlook 365 because from a cybersecurity standpoint, they meet our industry's required minimum standards. And they do provide some of this ability, but keeping in mind as you grow that you may want to consider other providers like Smarsh as you grow and change your business. So, we're going to go through kind of the different records you should be keeping in your business. And there's a lot. I'm going to try to work quickly through them. The list of all of these records will be made available to you. So if there's any that I skip over or just move through quickly, keep in mind you'll get the full list once the presentation is over. So financial records you should be keeping: cash receipt and disbursement journals, financial statements, ledgers, any loans from clients to the advisors or sale of the advisors or any affiliate stock to clients, checkbook, bank statements, cancel checks, advisory bills or statements, paid or unpaid, loan agreements, notes payable, notes receivable. Keep in mind that regulators will ask for this stuff, and I've actually had clients fined for not, for example, providing copies of canceled checks. So while it may seem like a pain in the butt to keep them, you do want to keep these, again, because regulators will ask them as part of a routine examination, and you have to be able to do them quickly since you're also subject to the rule where it should be in an easily accessible place. Organization docs you should be keeping, your org chart that comes up a lot in regulatory requests, your articles of incorporation, corporate minutes book, LLC partnership agreements, stock certificate books, schedule of all affiliated or related entities, names of any of the advisors, officers, and directors who resigned, and information regarding their reasons for departure. So especially if you have you're owned by a parent company, you have several affiliated entities under the parent company. You know, you manage different funds, and each fund has 3 or 4 entities involved that they all may be affiliated, you'll really want to keep a chart of all the different affiliated and related entities to ensure there's no confusion, but also to properly disclose those relationships. Form ADV records, a copy of each brochure and brochure supplement, any summary of material changes, a record of the dates that each brochure amendment, etc., were changed. Documentation describing the method used to compute your assets, a memorandum describing any legal or disciplinary events, backup documentation for any numbers you reported on Form 80, so number of clients, types of clients, a dated copy of the firm's annual offer letter. So this is the letter you send out to your client saying, hey, you know, here's a summary of the material changes we made on Form 80. Here's our privacy policy. Here's a copy of the actual ADV, or alternatively, you can ask for a full copy. If you want a copy of that letter that goes out, you want a list of all the clients the letter was sent to, and you'll want that log should, include if they were sent electronically, what email address it was sent to, what date it was sent. If it's snail mail, then you want to include the address it was sent to. You also want to keep a log of all the clients that requested a copy of Form ADV. Contract records. All written agreements entered into with the advisor with any client or otherwise related to a business and investment advisor. They're very broad. This includes solicitor agreements, outside money manager agreements. Keep a record of your advisory client agreements that you're using, the actual form or template or whatever, so you can track changes to the agreement. Also, if a regulator comes in and requests copies of the investment management agreement for a client, and the client signed on 4 years ago, you want to be able to show the agreement that was in place at that point. Standard fee schedule, all powers to tax or anything else that gives you discretionary authority, you want to keep those up. Solicitor arrangement. You'll want written acknowledgement that the client received the solicitor disclosure document, as well as a copy of the firm's disclosure document. You want a list of all the people that are compensated for soliciting clients, all clients that the advisor is paying a solicitor fee on, and then all agreements, correspondence, and disclosure documents for third-party solicitors. Code of ethics records. So you want a copy of the actual Code of Ethics, and keeping in mind that you have to keep your records, again, for a minimum of 5 years, 2 of which are in an easily accessible place, generally in your office, a record of any violation of the code, written acknowledgments for each person who's a supervised person that they've read it, insider trading policies and procedures, a list of when supervised persons joined the firm or when they became supervised persons. Let's see. Personal trading of employees, guides for monitoring personal trading. Let's see, the receipt flow and use of non-public information, any fee splitting or revenue sharing arrangements. Personal security transaction records. So if you allow as part of your code of ethics for employees to have personal brokerage accounts, then you want to make sure that you document all of your access people, their initial, so when they first become an employee, their initial holding report, and then their annual holding report, and then you want quarterly transaction reports. And generally you'll request that the employee have duplicate statements sent to your firm. a record of any decisions to approve securities and IPOs or limited offerings, brokerage accounts, disclosure forms, a list of all the accounts that a employee has, transaction pre-approval documentation, and then if you have a list of securities that are being restricted, whether it's something that the company has a material interest in or a client has a material interest in, you want to make sure that's all documented as well. Advertising records. So any notice, advertisement, newspaper article, whatever, any communication that you circulate or distribute to 10 or more people, if it recommends the purchase or sale of a security and does not state the reasons for the recommendation, and also a memorandum for the investment advisor indicating the reasons. So any advertisement, any marketing you put out there, you want to keep a record of. If you make a recommendation but don't state the reasons, then you want to keep a memo for why you're recommending that security. Let's see, copies of any pitch books, one-on-one presentations like the one we're doing today, whether it's an online webinar or in-person seminar, brochures, pamphlets, promotional materials, newspaper, magazine ads, even stuff that may be digital, posts on social media, articles you may put up. If you're on the radio, whether it's your own show or you are a guest on another radio station and you use that material from being a guest on that radio show in your marketing, then you want a copy of that as well. So keeping all of that. This includes, believe it or not, business cards, letterhead, phone book ads, which really who does phone book ads anymore? But any of that should be kept as part of your advertising records. When it comes to the websites and blogs and Instagram and Facebook and all that, if you're doing several posts a day, doing printouts or, finding an application or some way of archiving all that material, that should be kept as part of your advertising record. Any performance return composites, you want to include the accounts in each composite. And there's some additional records you would have to keep in conjunction with those performance return composites. And then again, kind of all agreements, correspondence, separate disclosure with third-party solicitors and kind of what material and advertising they're using in getting clients for you. Client communications. This is really an important one. You want to keep originals of all written communications received and copies of all written communications sent relating to any recommendation made or proposed, any receipt, disbursement, or delivery of funds or securities, or the placing or execution of any order. Again, any circular advertisement notice sent to 10 or more people, then you'll need to keep records of that. Any client complaints, information about the process used for monitoring client correspondence or complaints, any service providers you may use that will help with that oversight. You want to keep those records. WST records. WST meaning written supervisory procedures. This is your compliance manual. You'll want to keep a copy. Now, as an SEC investment advisor, you're required to do an annual compliance review. So in all likelihood, there'll be edits to your manual every year as your business grows and changes. If you're state registered, you may not be required to do an annual compliance review, and you may not necessarily make changes when something triggers a review. So, for example, a change in your business, a change in the law, you know, a change in your growth or employee status or whatever. They may be specific events that trigger changes for you. You may not have changes that happen every year, but regardless, you have to have the last 5 years worth of compliance manuals available if a regulator wants to see them. Again, any records documenting your annual review, current inventory of the firm's compliance risks. So going through and doing your review, you're also going through your risks, your conflicts of interest, etc. All that needs to be documented. Any written guidance that you provide to employees regarding the risk assessment and the process for creating policies and procedures, information related to compliance testing, quality control, etc. Written acknowledgement of the manual by all of your supervised persons. Any training you do in regards to your WSPs, you want to make sure that that's documented. Any internal audit review, any documentation that you, for interim reviews, the oversight process for remote offices or, you know, independent contractors, all of those you'll want to keep records of. If you have custody of client cash or securities, then you want to keep a journal of all the purchases, sales, receipts, etc., securities for those accounts, a separate ledger for each client, copies of confirmations, record for each security in which a client has a position. Those are records you want to keep. Voting authority, I know, I'm seeing fewer and fewer advisory firms wanting to vote or have voting authority on behalf of clients. So you want copies of all policies and procedures related to the voting authority, a copy of each proxy statement that the investment advisor receives. An investment advisor can satisfy this requirement by relying on a third party to make and retain on the investment advisor's behalf a copy of the proxy statement, or may rely on obtaining a copy of a proxy statement from the SEC's EDGAR system. You want a record of each vote cast by the investment advisor on behalf of the client. An investment advisor may satisfy this requirement by, again, relying on a third party to make and retain a record of the vote cast. A copy of any document created by the advisor that was material to making a decision on how to vote proxies on behalf of the client, or that memorializes the basis for that decision. So what does material mean? Material means those matters as to which an average prudent investor ought reasonably to be informed before buying or selling any security of a particular company. So that definition really doesn't help. So what are those matters? I mean, you want to look at your due diligence. You want to look at the background management. You want to look at the solvency of the company. You want to look at financial statements. You want to see, what's underlying the decision to make a change and whether it's prudent to vote one way or another. Let's see, you want a copy of each written client request for information on how the advisor voted proxies on behalf of the client. Copies of the client disclosure telling them how they can obtain information about how the proxy was voted. Trading records. You want to keep track of any special instructions, any modifications or cancellations to an order, terms and conditions, the person connected to the advisor that recommended the transaction, person who placed the order, the account for which the order is entered, the date of entry, the bank or broker dealer through which the order was executed. If the order was entered into pursuant to the exercise of discretionary authority, time of placing the order, time order was executed. So a lot of these are going to be recorded anyway when you make an order through the custodian. Now, I will say, when you're talking about the person who placed the order, the person who recommended the transaction, that's why you want to make sure that each individual has their own unique identifying number, lettering, ID, login, etc., so that when these trades are made, these different items are automatically captured by the custodian. So when you make an order, your custodian's already going to take note of the time of placing, the execution, the date, etc. And a lot of these records, it's really just a matter of logging into your custodian's website and running a report. But this is why you want to make sure you have individual identifiers for each person that's involved in that process. You want to keep a trade blotter, list of approved BDs, list of affiliated BDs, list of all BDs that receive rebates, best execution report, analyst reports. These are all reports you want to be able, if you don't actively maintain them, at least have the ability to run a report to get this information. Now, best execution, that's something you should be doing at least on an annual basis. And we're actually seeing right now a lot of regulators coming in and asking firms if they've done a best execution analysis, and if so, to provide the documentation. And they're using it as a way to fine advisory firms, because something that traditionally advisory firms haven't been asked to provide or do, but it's something that you are required to do as an advisor, and just unfortunately many advisors haven't done. Moving on to portfolio management records. So report of names of securities held in all client portfolios, so especially if you're using model portfolios, you want to keep track of what securities are in those model portfolios. And then you want to keep track, as you change out the securities in that model portfolio, why. And you want to keep track of each iteration of the change, so you can go back and pull what was in the portfolio 6 months ago or 2 years ago versus what's in the portfolio now, and be able to document why those changes were made. So in any report, you want the name of each client holding interest, amount owned by each interest, aggregate number of shares, total market value. You want minutes of any investment or portfolio management committee meetings, if such committee exists. Names of any publicly traded companies for which employees the advisor serves as officers and or directors. Brokerage records. So we're talking about best execution, evaluation broker arrangements. So you want back documentation, any sort of soft dollar, benefits you're receiving, commission sharing arrangements, affiliated broker dealers, and then securities numbers of the firm or an affiliate with a market maker. Valuation records. So if you're using any specific pricing services, quotation services, portfolio accounting systems, you want records of who those people are, names of all fair value and any illiquid securities held by clients, and if any fair value process is used, and then supporting documentation for advisory fee calculations, including any performance fees, and then the manner in which the fees are calculated. This is especially important if you have discretion. A lot of state regulators will let you get away with not having to comply with the heightened requirements for custody if you solely have discretion, and that would otherwise trigger custody. A lot of these states are requiring that to get the exemption, from those heightened requirements for custody, that you provide the advisory fee calculations. You send them to the broker-dealer, you send them to the client. So that's very important that you keep that record as well. Client-related records. So a list of the accounts in which the investment advisor has discretionary power. Clients where the advisor is receiving a solicitor fee. List of clients the advisor is a sub-advisor to. A list of all current clients, including your clients that are subject to wrap fee arrangements. And you should have their name, account number, balance, type of account, whether they're a related person, the custodian, whether the custodian sends periodic statements, whether or not the advisor has discretionary authority, whether the advisor or any affiliate or officer acts as trustee, co-trustee, or successor trustee, or has a power of attorney. Whether you have custody, the investment strategy, the portfolio managers, if they have a directed brokerage arrangement, the value for the purposes of the advisory fee, whether they pay a performance fee, whether the client receives statements directly from the custodian, whether fees are paid directly from the client's custodial account. I mean, you can still have discretion, but not necessarily get paid out of the client's trading account. You want a record of all the trades placed for your clients, the trade blotter, total value of the assets under management, list of all clients lost, including the reason, termination date, and asset value at termination. And then the names of any sort of financial planning, pension consulting, or other advisor clients not included in this list. Now, I know it seems like a lot, and a lot of it are records or reports that you can pull directly from your custodian. But you are going to, I have seen regulators come in, and I have seen regulators ask advisors, they'll ask for, 10 to 20 random clients. I want to see the records on these clients. So one of the things you want to be able to do is if a client has left or the relationship has terminated for any reason, when it happened, why. And then you also want to be able to produce these client file records. So your investment management agreement, your new account forms, trust documents, estate paperwork you may take, tax documents. You want written acknowledgement of receipt of Form ADV, written grant of trading and discretionary authority, investment guidelines, restrictions, any reports you provide to them, proxy voting reports, written instructions for directed brokerage, fee invoices, statements, confirmations. All of that should be a part of your client file record. And I can't tell you how many times I've had an advisor come to me where a regulator is asked to see, so say it's a state regulator, and you have clients in 5 states, and say the Pennsylvania comes along and says, we want to see, client files for all your Pennsylvania clients. You're going to have to be able to present those records. Where applicable, not every client's going to direct brokerage, for example. But you want to be able to produce, at a minimum, a current contract for services with the fee clearly stated, and the fee better match what you're actually charging the client. You want to have suitability information. You want to have all their information related to their investment strategy, risk tolerance, knowledge of securities, the level of risk they want, and then their goals. You want their tax returns. You want to know immediate liquidity needs. These are all things that need to be documented in their client files. And then, a lot of times they want to see the reports that you are providing these clients as well. So it's important to keep that. And I've had several clients come to us after getting fined for not keeping complete client records. So we move from client records to employee records. So it's important to kind of keep track of who's had supervision or has had discretion in your client account, who's served as an independent contractor, who's been an IAR, who's left, when do they terminate, who's been providing investment advisory advice, who's been disciplined. And then for licensing and registration for each of your IARs, you want a copy of their current U4, initial and renewal forms for the firm in each IAR, list of all states the firm is licensed or notice filed it, and then which IARs are practicing in each of those states or have the ability to practice in each of those states. So we're coming down towards the end here, and we're going through kind of miscellaneous records now that either you should actively maintain or should be able to very quickly generate a report that has this information from a third party. So a list of all your service providers, the due diligence you conducted to evaluate them before making them a provider, due diligence for sub-advisors, solicitors, names of any joint ventures or other businesses, and then in terms of information processing, reporting, and prediction and protection, safeguarding client information, what guidance have you provided for protection of customer records? Do you have documentation of controls of employee access? Do you have doors that require some sort of fob or key or some sort of other way to enter that's not available to everyone? Documentation of electronic access. So if you're cloud-based, do you require, Google authentication? What kind of firewall configuration do you have? If you are based on the cloud, who's your provider? What is their cybersecurity policy? What are their access? What are their controls to accessing the information that you're keeping with them? And then also just as something as simple as all of your computers, your tablets, your cell phones. Do you have antivirus software on them? Do you have security patches and upgrades? Are those all being done? And then, of course, the advisor's business continuity plan and disaster recovery plan. What happens if there is a hurricane? What happens if there is a hack? What is the plan? And then we have kind of what I call, quote-unquote, legal records. Now, obviously, you don't want to share correspondence with your attorneys because if you turn that information over, then you're waiving that attorney-client privilege. So when I say legal records, I'm talking about things like correspondence with regulators. Now, if it's your attorney's correspondence with regulators, you do not turn that over to any examiner, which is why it's important if you have an email provider to create some sort of scrub list, a list of email addresses where if there is a request for emails between, August 1, 2017 and September 30th, 2017, all the emails in that time frame, that this list of email addresses won't be produced. Any threatened, pending, and settled litigation or arbitration that includes a supervised person. You want a description of the allegations, the status, a brief description of any out-of-court or informal settlement, and then past regulatory deficiency letters. Now, when it comes to litigation, if you do settle, most settlement agreements are going to be confidential. You want to make sure they're marked as such. So if a regulator does ask for it, you can say it's a confidential settlement agreement, and you can provide a brief description of it. Some may really push it, and then you're going to want to make sure that if you produce that documentation, that you're asserting your rights to confidentiality. And again, that's something that you'll want to bring in your attorney to make sure that that's asserted appropriately. And then any sort of deficiency letter, whether it's from a state regulator or the SEC, regardless of whether or not it includes a disciplinary action. So you can get a regulatory deficiency letter that says, hey, you know, we noticed these things missing or these things weren't done, you need to fix them. And that's it. And you can also get deficiency letters where you're being fined, where you're being suspended, where you're being asked to do or undertake certain remedial actions to fix the issues. So regardless of what disciplinary action, if any, is involved, you want to keep records of all those deficiency letters. So I know we went through a lot of information. Obviously, the list of all the different records, it's not exhaustive, believe it or not, even though it may seem like it is. So it's kind of a good way to understand just all the things that you have to maintain. And this is regardless of whether you're state or SEC registered. You know, someone with $2 million AUM has the same compliance responsibilities as someone with $20 million, $200 million, $2 billion. Granted, the $2 billion is going to have more records to keep track of than the $2 million, but if you're engaging in the same kind of services, these are all the different kinds of things you're still going to have to maintain and have easily accessible. So, if you have any questions about your compliance, give us a call at 770-462-2118, or you can email us at compliance@myralawyer.com. Thanks, everyone.